Welcome to another edition of the Crotchety Old Men podcast, where we'll give you information, education, and expose you to everything financial. My name is George Crumley. I'm a residential investor, and I'll be your host today. And with me in the studio is Paul P.C. Clements, our holistic doctor. Good morning, Paul. How are we doing?
We're doing great, George. It's a great day. I'm 6 feet above, which is about as tall as I'm ever going to get in this life. So I'm certainly on the right side of life today. Today we have a special guest with us today, Oronda Smith, who represents Smith Law Firm. We're happy to have her today, and we're going to be talking about some estate planning, how to do it, what are the advantages, what are the disadvantages, and so forth. So we're happy to have her with us today.
Great. Welcome to the show, Oronda. How you doing today?
Doing great. Thanks so much for having me today. I'm excited about being here and talking about estate planning. But as PC said, I am an attorney, so of course I got beginning attorney disclaimers.
Hello. All righty. So now that we've dealt with the formalities, let's talk about estate planning for a bit. What is estate planning?
So estate planning is anything, or it's the preparation that you do for yourself and for your beneficiaries in times of need, for when you can't speak for yourself, can't speak up on your own behalf, and all the way until you pass. Also, a part of estate planning can be end of life planning, among other things. But the first thing I always tell people is that everybody has an estate. Some people, or a lot of people, come to me and they think, well, I don't have much, or I don't have anything. Well, everybody has an estate. Even young people have an estate. All the way as young as, I would say, 15, you can start making your will. That's a beginning piece of estate planning. But before I dive into that, I gotta say, of course, I'm a Georgia attorney, and every state is different. So some things we talk about today will be from the Georgia attorney perspective, and you need to check with the laws in your particular states to make sure it gels. A lot of things are similar, but a lot of things may be different, particularly in those states like California, Texas, that have these different kinds of marital rights, that have community property, these community property states. That completely changes people's estate planning and the way their estates are handled. So I would definitely say that in those states in particular, but in every state, you just want to make sure to check with your local attorney to make sure that these things are applicable. But in general, these basic estate planning principles are applicable. And I'll say one of the first things you should do as a part of an estate planning is just sit down and think. Think about what can you touch? What do you own? What do you have? And those things might be as small as a favorite record, or for a young person, it might be, for my son. My son is an athlete, for example, and he has hundreds of trophies and medals. So that's a part of his estate. So that's what I mean when I say that everybody has an estate, no matter how young you are. You have an estate, and you can start planning your estate plan generally in states as young as 15 years old.
Okay, now what is the difference between an estate plan, and it may not be a difference at all, but an estate plan versus a will?
Okay, so a will is a part of an estate plan, along with some of the basic parts of your estate plan are going to be your powers of attorney, your advance directives. In Georgia, it's called an advance directive. Some places call it a power of attorney for healthcare, or durable power of attorney for healthcare. They have the word healthcare in it, but But what that advance directive does is, in the event that you can't speak on your own behalf, if you're hospitalized or you're ill or you're incapacitated in some way, it appoints a person who can speak up for you, and they have to do the things according to how you've written, or they should do things according to how you have written them down in your advance directive. That advance directive is one of the basic building blocks to your estate plan. It'll say whether you want to be resuscitated or not, if you want them to take all measures to keep you alive, if you want them to let you naturally pass, if you want them to feed you, if you want them to withhold food and water, or just to keep you comfortable. It has all those kinds of details in it. And that's something that you should do as soon as possible, because of course we never know when something unfortunate may happen and we're not able to speak for ourselves. So that's one of the first estate planning documents I would say do. At a certain age or in certain circumstances, the next very basic document are your powers of attorney. So, and when I say very basic because they're generally easy for attorneys to prepare, and it's cost effective at this stage. When you don't do it, you can still get your business taken care of, but it's much more costly. So, and that's the point of the planning part. Just like insurance, if you have it, you might only have to pay a copay, a small amount. You've invested in your insurance ahead of time. If you don't have it and something catastrophic happens, you have to pay that full value out of pocket. So we want to have the proper planning up front so that we can keep the cost as low as possible and still get the business taken care of that we need to.
Okay, so a couple of things you mentioned, Oronda. You mentioned an advanced directive. Okay, so now is that a will?
So an advance directive is not a will. The advance directive only tells what you want to be done with your health care in the event you can't speak for yourself. A
Gotcha.
will is a tool. So there are the basic tools of estate planning. You have your powers of attorney, your advance directive, you have your wills, and you have trusts.
Okay.
I would say those are the basic four components of estate planning. And then kind of as an aside or as an addition, then you have certain types of insurance that are a part of an estate plan as well.
So what happens? You put an advanced directive together.
Yes.
The advanced directive instructs what to do in the event that a person cannot articulate for themselves what kind of care they want. The person dies. What happens after that? What happens after the person dies? Who says what about how the estate is going to go at that point?
So if you have put an estate plan in place, then you'll either have a will, a trust, or both. Usually, if you have a trust, you'll have a will as well that will dump all of your assets into the trust. And that's what would take place afterwards. All powers of attorney and advance directives dissolve immediately at the point of death. So that advance directive is no longer applicable. The person you appointed in your advance directive does not have any kind of power anymore. The person you gave your powers of attorney to no longer have any power over your assets or over your body even. So
And that would be your power of attorney.
the powers of attorney would be dissolved. It's your
Okay.
will. It's your will that then happens or that kicks into place after you die. Your will does not automatically kick into place though. Okay. So your will is simply an outline or directions that you get to say what you want to be done with your body, with your assets. In order for the will to be enacted and for the powers to be carried out, you would have to go into the probate court and apply for the will to be probated. And that switches from estate, that's the switching point from estate planning to estate administration. So what we're doing today is we're putting everything in place so that at that point of death, you have guidelines for those you leave behind as to what you want it done with your person and with your assets. And that would be either through a will, a trust, or both.
So now, explain to the public in layman's terms what the differences would be between, and you went through some of it already, what the differences between a will, a trust, and what was the third thing you mentioned?
Well, I was talking about your powers of attorney.
Powers of attorney, yes.
So powers of attorney are documents that give power to somebody to act on your behalf while you are living. They only work while you're living. Georgia
Okay.
has what's called a statutory power of attorney. That's one that you can go directly to the law books and copy it word for word and just fill in the blanks and give that power to somebody else to act on your behalf. But be careful. When you give somebody a power of attorney, that means that they can do what you can do. So number one, you want to make sure it's somebody you trust implicitly. People often automatically want to make their oldest child their executor, which we'll get to in just a second when we talk about wills, or their attorney in fact, which is the person who you give power of attorney to. And I say, pause on that, because your eldest child may not be the most responsible or the most trustworthy. It may not be any of your children. Powers of attorney can differ, so they may be specific to a certain circumstance. You want to choose the person who is most reliable and most trustworthy in that particular circumstance. Again, powers
Gotcha.
of attorney are for while you're living, giving your capability to transact business to a third party. A will is a document that has specific state formalities that outline what you want to be done when you die, who you want all your assets to go to, your home, your boat, your cars, your charitable contributions, any of your money, your stocks, your bonds. How you want to be buried is often in your will, and any business that you want to be taken care of in your will. A trust is a slightly more advanced instrument that puts the power to govern it in a third party's hand for the benefit of some additional people. So a trust would be the most complicated of those devices, and therefore also the most expensive to prepare. But the trust is also allows people to what they call rule beyond the grave. So a trust is the document that if you want to dictate the how and why somebody can do and how they can do it and under what circumstances, the trust is the type of document that you prepare in order to govern that person or dictate the rules to somebody about what you're leaving to them, even though you have since passed away. So trust, dictate rules and details, store things beyond the grave, or rule beyond the grave. It also can be a protection mechanism from certain creditors. That's even more complicated, but that's the most complicated instrument. Next is the will. Everybody should have at least a basic will, and then the easiest again is the power of attorney.
Hey, Oronda, those are all good factual points. I'm particularly interested in the will, and I know you kind of touched upon it. I'm not sorry, not the will, the trust. I know you touched upon it a little bit. So, can you give me an example of when a person would actually need a trust as opposed to just a will?
Okay, sure. I usually recommend to people that have significant assets, put them in a trust. And when I say significant assets, I mean if for example, if you're a real estate investor and you have multiple properties, or if you have a business that you run, if you have stocks and bonds and things that might fluctuate in value, things you want to hold for a long time, or you want to operate, or you want to operate for your legacy, for years after you've passed, I usually suggest that a trust is an instrument you may want to consider. Um, if you are just talking about, if your only assets are your car and your house, and maybe you just have enough money in the bank to meet the end of the month's bills, then it's probably not necessary to invest the money that you would spend creating a trust, um, into that trust. You would probably just be fine with just a will, just basic straight passing down a house, um, a car, and less than a couple of $1,000. A will is fine.
Oh, okay.
But for those, I know that we have real estate investors who listen, and people with small businesses online. Usually, you have enough assets you that you that it's worth putting in a trust. It's worth creating a trust, and spending that upfront money to protect those assets down the line.
Oh, okay. So let me ask you this: if you are one of those individuals that have stock accounts, and obviously I'm going to say outside of the real estate holdings, but I know they request that you do a beneficiary. So if you have a beneficiary assigned on, say, your stock accounts and any other paper holdings such as those, or does it still make sense to have a trust?
So for your stocks, the trust can be the beneficiary. When your stock accounts ask for the beneficiary, you can make the trust the beneficiary. And remember, I said the trusts are for ruling beyond the grave. So if you make the trust the beneficiary on your stocks, then those stocks will get dumped into the trust. And you can say, I'm leaving these stocks inside the trust. You'll say, I'm leaving these stocks to my grandchild, but only if he graduates college. As opposed to if you pass and just put his name as the beneficiary on the stocks, then they just all automatically go to him, and he might squander them, or he might, do whatever. But like that trust allows that protection and allows you to dictate certain parameters around the passage of that. But I'm glad you mentioned certain assets that have beneficiary provisions on them. Generally, if you put somebody down as the beneficiary, it moves it out of probate, means it's a non-probate asset, which means that it automatically goes to that person when you die. It does not have to go through the will process. It does not have to go through the trust process or the estate process at all. It automatically goes to that person upon your death. So that's why when people have life insurance, one of the first things they do, they contact a life insurance company, and they say, I think I might be a beneficiary. Hopefully they are. I've seen it happen both ways. But hopefully they are the beneficiary. The life insurance company will send them the appropriate documents. That money goes directly to the person. No creditors can touch it. It's not a part of the probate asset.
So let
Oh,
me ask
great
you this:
information.
you mentioned price. What are we looking at in terms of a ballpark figure that it would take to set up any one of these instruments or all three?
Okay. So I will say for power powers of attorney, let's start with the least expensive. Powers of attorney and advanced directives, you're usually looking at less than $300 per document. So, like I said, there are multiple types of powers of attorney, but I would say for those things, less than $300 a document. For your will, a simple will, $450 and up. So once wills can have their own trust provisions. You have multiple types of beneficiaries, multiple classes of beneficiaries, and wills can be from 2 or 3 pages to 20 or 30 pages. So depending on the complexity of your will, I would say wills generally start at around $450. Trusts usually start around $1,500. So that's why I said, and it depends on, of course, the complexity of the trust and what all you're placing into the trust. So that's why I said the easiest and least expensive thing to do, get your powers of attorney in order. Oh, even less expensive. The first thing I want as people to do as a part of their estate planning, particularly if they're married or have a significant other, is look at your deed. Look at the deed to your house. Make sure that if you want to pass your house to your spouse, that you have what's called a joint tenancy with right of survivorship deed. So if you are of an age where you bought your house in the 80s or 90s, sometimes it was not automatic that you have a joint tenancy with right of survivorship deed. It might just be both you and your spouse on title to the property. That would be what's called tenants in common. Joint tenancy with right of survivorship automatically leaves the entirety of the property to the other person once the first person dies. If you don't have joint tenancy, if you just have both of their names on it, it defaults to tenants in common. That person gets 1/2 interest. So they have their half, and then your half has to go through the probate process. So if you have children or stepchildren or all kinds of things, they can get into a mess, and they'll be sharing that property with somebody. But so I always tell people the first thing you want to do is look at your deed and make sure it says what you want it to say. I can't hear you. Can't hear you.
All good questions. I think PC kind of lost a little bit, but all good information. And that's a good point to kind of transition from our discussions about wills and trust to, because you're also a real estate attorney. So let's talk about a little bit about real estate from a attorney perspective. So how often do you get involved in real estate transactions, and is it really necessary to have an attorney when you say you're closing on your personal residence?
So every day. So I've been a real estate attorney for 18 years. And in the state of Georgia, real estate transactions are required to be facilitated by an attorney. So if somebody tries to get you to sell them your house, or you're trying to sell your house and somebody is attempting to buy it, make sure you have an attorney involved. The state of Georgia requires that for your protection and for the buyer's protection. Every day, or fraud is rampant. I'll say that. Fraud is rampant. I've seen people take money from others supposedly to buy their house, or and that house belonged to a different person. People squat in these vacant houses and then sell them, and they're not the true owner. Well, unless you have a licensed Georgia attorney, a licensed real estate attorney, you won't know. Georgia attorneys who are real estate attorneys offer title insurance, and that is something that everybody should have on the property that they own. It protects you in the case that anything comes up of record. So all deeds, when you buy your property, your deed is recorded of record in the Superior Court of your county. But sometimes judgments attach, or somebody has done work on a house and they haven't paid for it. That creates a lien. And those are all things that could jeopardize your ownership of the property. What real estate attorneys do is do a 50-year search to make sure that there's nothing that could jeopardize the ownership of the property. We make sure that when you buy a property, you're buying it free and clear of all of these liens and judgments that the previous owner or the previous owners might have collected against them. We make sure those are paid off at closing or cleared at the time of the closing. So yes, not only is it necessary, but it's illegal to transact the passage of title without a closing attorney, without a Georgia licensed attorney facilitating that closing transaction.
Now, since we're on real estate, I've got a question, a burning question. You're a real estate investor. What I need to know is which is the most advantageous to a real estate investor, a TIC or an LLC?
So a TIC refers to, in Georgia, tenants in common, and that's really just a way of holding the property. So that would come into place if you were buying it jointly with another person or with a group of people. You might have a group of 2 or 3 investors. You buy a property and you all put your name on the deed. You all would hold it as tenants in common unless there was some other additional language on it. And all that says is you each have an equal interest. The LLC, however, is a protection mechanism. So most real estate investors store in an LLC. The reason is because this separates your investment assets from your personal assets. For example, if a tree were to fall on your property and hurt somebody, or if somebody were to slip and fall on your property, they could sue, and your property was found to not be maintained as it should. They could sue the LLC. The LLC contains the property. They could not touch your personal assets. So, and and nothing that you own personally would attach, because that house, that property would be in the name of the LLC, and the business that you transact would be in the name of the LLC. So I usually tell investors to put your property in an LLC or some type of corporate entity. Now, the difference is most real estate investors choose an LLC over a corporation or a partnership because of a tax trick or tax benefit for LLCs. And that has to do with, and I am no tax attorney, but that has to do with stepped up basis. So in an LLC, you get the benefit, you get a better benefit of the money that you have placed in the property through your LLC than if you were to do it through a corporation. So that's why most investors use an LLC to put their real estate property in. Again, LLCs, tenants in common, is just the way you hold the property, but it still allows you to be subject to liability personally. LLCs protect your personal assets and your personal liability from being in jeopardy with your real estate investment.
Wow, this has all been so much valuable information. So, if somebody wanted to get in touch with you to further the conversation, or to even get them to represent you in some of these transactions, how would they do that?
Thank you so much for asking. Oronda Smith is my name. The name of my firm is OM Smith Law Group, and I'm located in Morrow, Georgia, which is just about 10 minutes south of the Atlanta airport. My office number is 678-804-5533. The website is omsmithlaw.com. And my email address is Oronda, Oronda, at omsmithlaw.com. I welcome any questions, any emails. Email is probably the easiest way and most efficient way to contact me.
Thank you for joining us, Attorney Oronda Smith. It has been a pleasure. And thank you for sharing so much valuable information on estate planning and real estate law. We definitely would like to have you back on future shows. And for our audience, make sure you continue to follow us, the Crotchety Old Men, on Google, Spotify, iHeart, Apple podcast platforms. And as always, in closing, I'd like to share a simple nugget, and that is, in all you're getting, get understanding. And until next week, this is George Crumley signing off and saying peace.